Hello, everybody, for joining us today. I'm Crystal Park, and I am an NCA LSO lawyer licensing candidate and a recent graduate of the University of Toronto Faculty of Law GPLM program. We have a fun and interactive event prepared for you today, and we hope that you gain valuable insight on how to survive, but not only survive, thrive as a non-native English speaker in an English-speaking legal world. This event, Up the Ante, Don't Shoot the Messenger, is supported by the ITLN CA networks. And I would like to invite the president of the association to say a few words about the wonderful things that they're doing for the internationally trained lawyers community here in Canada. Antonio?
Thank you, Crystal. It's been a privilege for me to work with a group of international trained lawyers, national committee accreditations, candidates and lawyers who support the newcomers lawyers from all over the world to Canada to settle here and to make their experience better, faster, and happier, I would say. So we created the ITLNCA networks a few years ago. We've been working together. Right now it's a not-for-profit corporation, and it's basically the joint effort of equality-seeking legal professional associations and stakeholders committed to improve international trained lawyers' experience in their career exploration, certifications, and licensing processes in Canada. There are 6 associations that are supporting, and other stakeholders, but basically 6 other associations that are supporting our work: the Canadian Hispanic Bar Association, the Federation of Asian Canadian Lawyers, South Asian Bar Association of Toronto, Arab Canadian Lawyers Association, the Hellenic Canadian Lawyers Association, and the Canadian Association of Black Lawyers, and we expect to have more of them to join us in the future. 2 events that are coming up: the on-campus interviews for National Committee Accreditation candidates and international trained lawyers coming up in 2021, but in particular an information session that the ITLNCA networks put in place for November 3rd. I believe that information it's going around in social media, and if you want more information, please send me a text and I'll give it to you through the chat box. Thank you, Hinju, for having me today. I'm happy to be here. I'm going to be the one in the back just controlling recording and all the technical things, and that's why that's not the reason why I went to law school, but I'm enjoying this piece of my work. Thank you.
Thank you very much, Antonio. So let's get right into it. Let me introduce our fantastic presenter for today. So Myriam Seers is a lawyer with Torys LLP. Her practice focuses on litigation and dispute resolution. She has appeared as counsel before the Supreme Court of Canada in international arbitrations under the ICSID, UNCITRAL, and ICC rules on all levels of Ontario and Canadian federal courts, and also administrative tribunals. She also has taught advocacy skills and participated as a faculty member for the Foundation for International Advocacy workshop on questioning fact witnesses in international arbitration, and also taught in many different leading programs with respect to the International Arbitration Advocacy Program in different parts of the world. She's also judging moots such as the Vis East and the Canadian national rounds of the Philip C. Jessup International Law Moot Court competition. I think it's also very fitting for me to say a little thing about how Myriam and I met. So we actually met around this time of the year last year at a speed mentoring event organized by FACL and CHBA. And I think that all throughout, I've really witnessed her commitment to mentoring law students and also lawyers in their early careers. Other than that, I think that what really struck me about her when I first met her was her love for the area that she practices in, and also languages. She has a strong passion for languages, and I think it's very exciting that she was able to bring this all together, her love for the law, languages, and also teaching in her new passion project. And I'd love to invite Myriam to actually say a few words and introduce your new passion project.
Hi everyone. Thank you so much for joining us. Thank you so much for joining us tonight. I know everybody's busy and has probably got webinar fatigue, so we've done our best to try to make this entertaining, and I guess you'll be the judge of that, whether it is or it isn't. Crystal, I can't possibly improve on it. I should just leave right now because I can only damage my reputation going forward by going through with this presentation after everything that you've just said. But no, thank you very much. And you're absolutely right. I have probably 3 great passions in my life, being law, in my professional life, I should say, being law, languages and teaching. And so it occurred to me that I could start this English for Lawyers project and marry all 3. And has been a very exciting adventure so far, and I'm just getting started. So actually, this is the first time I'm giving this particular presentation, so I would be especially grateful to all of you if you would give me some detailed feedback if you're up for it afterwards, because I would like to keep giving this presentation and variations of it to other groups. So, but this is the first time. So I started English for Lawyers over the summer because I had nothing to do, and I thought, why not start a new company? But really it was born out of the fact that I have a lot of internationally trained lawyers practicing in Canada in my circle, as well as lawyers from elsewhere in the world practicing in their home countries, but that have to operate in English in my circle. And I noticed that a lot of these people really struggle with having to use English in their day-to-day life. And we all know how difficult being a lawyer is, even in your own language. So I can't even imagine what it's like to do it in a second language, mostly because law is language, right? Law is language. It's not like if you're a doctor, your language is medicine, it's cells and science. If you're a scientist, it's physical formulas, etc. And so the demands on for language in other professions are maybe lesser than in law. So anyway, so I perceived a high need for people in those categories, whether it's just language training in and of itself in terms of writing, grammar, vocabulary, that type of stuff, or legal writing skills, because as I'm sure everyone who's on this webinar knows, the style in the English-speaking world has very little in common with the style in other parts of the world, which we'll review today. Oral advocacy, which is also completely different, but in particular between common law systems and civilian systems. And then just cultural stuff, which is probably the most confusing of all for everyone who's ever tried to operate in a different country from where they were born. And it goes from really, really tiny things like not getting a joke that someone is making because they're referencing a cartoon show that they watched when they were kids, and everybody else from the same country knows what they're talking about, but they have no idea, all the way to, and we're going to spend some time on this later, idioms and expressions, and there's a wink to that in the title of this presentation, which if it left you very confused, well, that's the point. And anyway, so a lot of these different types of needs, and I could notice that as I was interacting with people in my network, and thought, well, why not? I think I can have something to offer because I have spent so much time being a student of languages. I speak French and Spanish. I mangle Portuguese. And I understand Italian, some German, and some Mandarin. So I certainly know what it's like to try to get your point across in a different language. So anyway, so I, with all of that preamble, started this little venture. And what I'm doing is offering seminars like this, various places, like in law firms for lawyers in law firms. I've started several down the path for several of them in Spanish-speaking Latin America and in Brazil as well. Individual one-on-one consulting, and many of my clients are on this webinar, so thank you for supporting me, and thanks for coming. where we do basically with one-on-one consulting, it's anything and everything. You sort of, I see where you are now. You tell me where you want to go, and together we figure out how to get you there, given the other demands that you have placed on your time. And that can be, you know, Zoom sessions once a week, or it could be WhatsApp messages 5 times a day. Whatever it is that you need in order to get you where you and the client with whom we are doing that is on this call, and she that person can identify themselves if they wish. But anyway, so there's so many different options, and I'm really enjoying it. So that's the preamble. Thanks for joining, and I hope you enjoy the presentation.
Thank you very much, Myriam. So I'm gonna actually just go over the housekeeping rules, and we're gonna get started. So housekeeping, I'm gonna say the general, please mute yourself if you are not talking or do not intend to, you know, be speaking for this event. But on the other hand, we really need you to participate, because this is an interactive event, and you will get the most out of it if you do participate in the polls. We will have polls. We will also be asking questions, so please you know, use the chat box to provide your answers. And for the more courageous ones, you can also turn on your camera, raise your hand, and answer the questions orally. That being said, please note that this event is being recorded. So yes, keep that in mind. Okay, well, I think that's it for me. And without further ado, Myriam, the floor is yours.
Thank you. All right. Step 1, figure out how to switch the slide. There we go. So I've structured this, or we've structured, I should say, this presentation into 5 broad parts, and it's intended to cover large areas of interaction with English that lawyers from outside the English-speaking world would need to deal with in their practice. Obviously, each of these areas is a semester-long course in and of itself, if not a lifelong journey. So we're not going to be able to cover everything, but what I thought we would do is give you a little bit of a flavor of what training in respect of that type of area would look like. So you have some notions of it, and obviously then if you'd like to get more training on that, that could be discussed. So the first area is email writing, because obviously that's what many of us spend most of our days doing. So what we're going to do under that section, which is actually the longest one out of all of these sections, they're not evenly balanced, by the way. So the first one is a big chunk of the presentation. So what we're going to do is start with a badly written email, and then edit it together until hopefully we arrive at a well-written email at the end. And you guys can be the judge of whether it's well-written or not. The second part is a little bit of contract drafting. Now, this specifically is an art form, and so we're only doing a tiny little flavor of it. But the idea here is to see the importance of precision by noticing an ambiguity or an imprecision, something that is not precise, and how that can lead to a lawsuit. The third part is about longer documents, and because of this format, it's just not practical to work with a longer document directly. But what I've done is given you some points to think about that relate to the structure of longer documents, and in particular, the way that structure in the English-speaking world may be a little bit different than the structure that is common in other places. The part 4, we're very excited about, so hopefully people can stay logged in until then. We're going to go on a field trip to the Supreme Court of Canada. Such things are possible in the virtual world. We can all head over to Ottawa and listen to a Supreme Court of Canada case this evening. It's possible. And then last but not least, which is something that we say a lot in English, it means when you're talking about the last thing that's in a list, but you don't want to make it seem unimportant, you say last but not least, idioms. So idioms are expressions that we use. Every language has them. They're almost impossible to translate, and they tend to be the very last thing that a person becomes comfortable using in a second language. I would say my Spanish is a fairly strong language, and I haven't even scratched the surface in terms of understanding the idioms, and it doesn't help that they're different in different countries of the Spanish-speaking world. The same thing is true in English. And we have a lot of them, and this has become a bit of an important aspect of the way I like to teach English for lawyers. You know, people say, "Oh, idioms, you know, that's what your grandmother says." It's not important. So to test that, for a 2-week period, I counted how many idioms I either said or heard, and those are obviously the ones I noticed to be able to count them, in a professional context. So I did not count any that were purely personal, you know, around the house type stuff that my grandmother would use. And it was 75. 75. So just to show how important it is to learn them. So we have a segment about that at the end. And you'll have to stick around until the end if you want to find out what the title of the presentation means. All right. So, Halloween. It's Halloween in 2 days, and it's a very important holiday here in Canada. Despite the fact that COVID is basically canceling it, we thought we'd try to keep the Halloween spirit alive by using a Halloween-inspired case for our work on each of these 5 topics. So here's the case. We are counsel. We together on this webinar are together counsel in a law firm that is called Up the Ante LLP. And we act for a client who's called Skeletons in the Closet, Inc. And Skeletons is a costume rental company that specializes in renting high quality, spooky looking skeleton costumes. And you can see 2 examples of such to the left. Skeletons entered into a skeleton costume rental agreement with a company called The Devil is in the Details Corp. And under the agreement, Devil, the company Devil, agreed to rent 500 skeleton costumes from Skeleton, the company Skeleton. The costumes are to be delivered the morning of Saturday, October 31st, 2020, or the morning after tomorrow, in time for Devil's annual Halloween party, the devilishly spooky soiree. Devil has informed Skeleton that its party is canceled because of the COVID-19 situation. It will not accept delivery of the costumes, and it will not pay for them. It relies on the force majeure provision in the agreement. Devil is represented by Tom Riddle of the law firm Don't Shoot the Messenger, LLP. So we're going to be working with this case for the rest of the presentation. Now, our first task is to write an email to Mr. Riddle, the opposing counsel, and we've asked a junior lawyer in our firm to prepare a first draft, and this is the first draft. So it's from me to Tom Riddle, re-skeleton costume rental agreement. And it reads, "Dear sirs or madams, kindly instruct your client to accept delivery of the skeleton costumes it agreed to rent. The contract is extremely clear that Devil is in the Details Corp is required to rent the costumes. It says that force majeure does not apply in this type of situation, comma, because there's no inability on the part of your client to perform its obligations, comma, so there's no right to claim force majeure, comma, therefore your client absolutely must pay for the costumes, period. We hope that you will accept our sincere regards. Myriam Seers, lawyer, Up the Ante, LLP." So before I move on, take a moment to look at this and ask yourself whether if a junior associate gave you this draft, you would be happy to send it along to opposing counsel without any further editing And if you think it needs editing, maybe take a moment to think about what that editing might be before we do that as a group. I'll just give everyone a couple of seconds to look it over. We're not only writing about we're not writing about the contract generally. We're not writing about, you know, oh, thanks for entering into this contract, or, you know, this is the best contract we've ever had in our entire history of our company. We're writing about our assertion that the client, that devil, has breached the contract. So this title or this subject line is more descriptive of what we're writing about. And in the English-speaking world, anytime you can be more descriptive, you can be more kind of forward and point first with the purpose that you're writing about, the better. So this, I would say, is the better option. So tip number 1, use a descriptive subject line. Tip number 2, addressing and closing your email. So there are very few subjects that generate as much confusion as this. So I thought I would put up a little kind of cheat slide that, and by the way, everyone who's attending will get this slide deck by email, so you don't have to take notes unless you want to. So these are in general the addressing formulations and the closing formulations that you'll see in English. The top ones are, I say general because it works for informal situations and more formal situations where you know the person. So at least in North America, I don't pretend to speak for the Brits, but in North America, it's very uncommon to use last names for people you know. Very, very, very uncommon. And when you do, it's sort of like you're creating this distance. So it's not that it's rude, but it's strange. Like if you know someone and you're using their last name, they will perceive that as strange that you use their last name. So this is what I mean when I talk about cultural awareness. It's important for you guys to know these things because obviously you don't want to be creating mistaken impressions, right? So the top left is what we're going to use if we know the person. And the bottom is what we're going to use if we don't know the person or if it's a very formal situation. So we have Mr., Ms. It's no longer very common to use Mrs. or Miss in English. The more the difference used to be that Mrs. was for married women and Miss was for unmarried women. Obviously, that's kind of antiquated now to use that kind of distinction. So we use Ms. for all women and Mr. for all men generally, and obviously other titles like doctor or professor. And you see I've used colons, which are the 2 dots on top of each other, or commas interchangeably. In North America, you see both. In the UK, they tend not to use anything at all. So it would be hi, Tom, nothing, break the paragraph. Here we use either the colon or the comma. So on the right, we have the closings, which are really quite standard. So you have that as a we would say a cheat sheet. A cheat sheet is like something that you can just keep and rely on. So this is your cheat sheet for addressing and closing your email. So here we've done that. So dear sirs or madams, I hate a lot. But you do see it used if you're writing. Here's where you see it used. If you're writing to some sort of a government agency, like you're writing to Canada Revenue Agency or something, and you don't know who will be receiving it in that place, I guess it's okay. I would still, in that kind of situation, I would address it to the Director General or something. Like you can usually find a person's name to address it to, or if it's to a company and you don't know who to address it to, like the CEO is probably a good bet, usually. But I really don't like sirs, madam. So I've put, since we know opposing counsel, we know him personally, we put dear Tom. Okay, so email tip number 3, state your purpose upfront. So this is, it kind of goes together with the subject line, but this is another, as I'm sure you will have been told a million times in learning how to write in English, we're very point first. And when you think you've made your point first, redraft it so you make your point first more. You have to state your purpose immediately, and especially now with people's attention spans getting shorter and shorter. At Tories, we teach associates that the entire, like all of the important information in an email should be written in the first paragraph so that it fits on the first screen of your phone, because people will not scroll down there. And preferably in the like 2 lines of Outlook's so you capture your reader's attention, right, by telling them immediately why you're writing to them, and so that they are motivated to read the rest of your email. So here, so that was completely absent from the original version. It started with a demand that they accept delivery, but that demand didn't have any context to it. So what we've added here is a couple of lines saying we're keeping the same request that delivery be accepted, but we're saying why, and we're saying it in a way that if the person's reading it, if Tom is reading it on his phone, he will see all of this information in the first screen. So, dear Tom, I'm writing to ask that your client accept delivery of the skeletons it agreed to rent. The skeleton costume rental agreement requires that your client accept delivery of and pay for the costumes. So it's short and sweet, it gets to the point, and then we can elaborate subsequently. But if Tom only reads that, he already knows what we want. Now, take a look at the first sentence and see if you can find a spelling mistake. A phrase like "to ask that" takes the subjunctive in English. So those of you from Spanish-speaking places and Portuguese-speaking places and other things are very, very well acquainted with the subjunctive and might think that English doesn't have it, but it does. And we use it in that clause, so clauses with that are preceded by a request or a wish, a desire, a value judgment. And the way we form it is pretty straightforward. We use the infinitive of the verb, so the to something form of the verb, just without the to. So in the case above, I'm writing to ask that your client accept, because the infinitive of that verb is to accept. If we said your client accepts with an S, then that would be using the regular present simple. So it's a very small, unlike in other languages where the subjunctive changes the verb quite a lot. In English, it's very small, which makes it extremely hard to spot. And believe it or not, I see a lot of native speakers making this mistake all the time. So I've given you some examples on the right, which are all taken from legal practice. The applicant requests that the order be granted, not that the order is granted. It's important that the CEO sign the contract, not signs the contract. The plaintiff asks that the company accepts service of the pleading, not accepts. So quick grammar tip. It is not very common. It's very common mistake. I'm just responding to Xiomara's point in the chat about whether you would want to put the paragraph. Actually, I won't write it. I'll just tell you whether. So Xiomara is asking, should you put the specific provision of the clause in the agreement in the top paragraph? I wouldn't, because I think the top paragraph is really, the intention is to be succinct and get to the point, and these are the types of details that you might not need at all in an email, but if you do, it would be later down in the body, I would say. And that kind of detail would probably distract the reader from knowing exactly your point. Tip number 4 is a big one, making polite requests, especially in Canada, because we'd like to think that we're quite polite. So turn your attention to the highlighted sentence. Kindly instruct your client to accept delivery of the skeleton costumes it agreed to rent. I mean, that's a direct order, right? That is, you will instruct your client we are giving a direct order to opposing counsel to do something. And the fact that we've prefaced it with kindly, or if we put please, it doesn't really change the fact that we are telling them you must do this, which is really not very polite at all. Although you will see this all the time in legal practice. It's very, very common. Kindly do this, or please do that. It's not very nice. So the way that we make a polite request in English is by using words like could and would. The same kind of idea from the discussion with Xiomara earlier. By using these kinds of words, which are conditionals, we're adding on kind of this idea that the recipient is not forced to do the thing. You know, there's an option not to do the thing. Obviously, we are asking them to do the thing, but we're doing it in a more polite way. So could you please, would you please, perhaps you could is very common. I do this one a lot to associates within my firm. Perhaps you could send this email to the client today, or perhaps you could research that point. Would you mind? And then here, the last two, I actually use a ton, which are the more formal ones. So for example, if you were writing a letter to the court and you wanted to ask the court, say, to issue an order or something like that, to sign an order. You're writing to a judge asking them to sign an order. I mean, you should never say, please sign this order. That's a direct order to a judge. It's very, very bad. You should not do that. You should never make a direct order to a judge. But these formulations are really good. So we would be grateful if you signed the order. We would appreciate if you could let us know when the next available hearing date is. I use those two, the ones at the bottom, a lot with opposing counsel. So with that in mind, I'm going to go back to the previous slide here. I'm going to ask everyone to take a moment and redraft this first sentence in the chat, bearing in mind that you'd like to be very polite because you're writing to opposing counsel. And so this kindly instruct your client business is not very nice at all. So you have all these, another cheat sheet that you can use next time you have to ask counsel to do something. All right. No, we did that already, sorry. So here is my version, and I also moved it to the bottom because I thought it flowed better. Now that we have this kind of context at the top, we have the body in the middle, and then the last is the ask. Because we already kind of foreshadow the ask in the first sentence. So I put, we would be grateful if you instructed your client to accept delivery of the skeleton costumes at agreed to rent. And several of you came up with that as well, so perfect. That is tip 4, making polite requests. Tip 5, write shorter sentences. I'm looking at you, Spanish speakers. So, as will be very clear to many of you, English writes, the desirable sentence length in English is many, many, many times shorter than in Spanish and some other languages. This is my effort at taking the middle paragraph and turning it into something an English speaker would actually understand. So every time there was a comma, or almost every time, I broke the sentence and I started a new one. So the contract is extremely clear that Devils in the Details Corp is required to rent the costumes, period. Take a breath. Breathe in. Oh, good, you got a break. Now you can start the next sentence. The contract says, now actually here, now that I'm looking at it again, I could have put it because we said the contract in the previous sentence, but it doesn't matter. The contract says that force majeure does not apply in this type of situation because there's no inability on the part of your client to perform its obligations, period. I get a break, good. Okay, therefore, there is no right to claim force majeure, period. Your client absolutely must pay for the costumes. Now, obviously, these are very short sentences, and English absolutely permits longer sentences than this. But I think if you're a Spanish speaker or a Portuguese speaker, or otherwise a speaker of a language who has which tends to have long sentences, it can't hurt for you guys to default to this for a little while. And then when you master that, then you can maybe start playing around with longer structures. The other thing is that long structures in English, these were not only undesirable, but also grammatically incorrect, because you can't use commas in the same way. That goes beyond the scope of this workshop, but you have to, if you're going to be using compound sentences, you have to know how to use the connectors. So you don't have to know that if you just break the sentence every time. And then last but not least, we're going to edit and polish the draft. So we're going to avoid unnecessary intensifiers. This is advice for Canada. It's in the US, they're extremely fond of unnecessary intensifiers, like this is highly unacceptable and extremely objectionable and all that kind of stuff. Some Canadian practitioners do that too. I'm allergic to that. I don't think it adds anything. I think generally judges are very adverse to that type of thing unless it has a meaning. And if you overuse terms like that, they lose their meaning. Whereas if in general you don't use any terms like that, but then you use it once, then your point really comes across. So we'll avoid unnecessary intensifiers by removing the extremely, because there's no difference, best I can tell, between a contract that is clear and a contract that is extremely clear. Clear doesn't have degrees. It's clear or it's not clear. And then similarly, we are going to remove absolutely here. Like your client absolutely must pay, to just say must pay, because again, you can't absolutely pay. You can pay or you cannot pay. Or maybe you can pay at a discount, but you can't absolutely pay. Simplifying the language is generally a good idea. People tend to have a habit of using too many words in a first draft, so it's good to kind of dial it back in your second draft. So what we've done here is we've removed is required to, and we've put must, nice and short, clear. We've removed, so your client absolutely, to it, because we referred to the client before. I didn't catch this, but we could have done the same thing in the second sentence with the contract. We are going to use verbs instead of nouns. And again, Spanish speakers, you use nominalizations a lot, which English doesn't like as much. So instead of saying something like, there is no inability to, we will turn that into a verb, is not unable to. And just like we're going to simplify some of the overly complex language, we'll also revise some of the language that might be too informal to just strike the right balance. And here, I thought that using says in connection with a contract was maybe a little colloquial. So I put the contract provides, and provides is a very common word to use to describe what contracts say or what statutes say. And you see, I just said the word say, which is okay to do because I'm speaking, but when you're writing, you want to be a little bit more precise. All right, so this is what it looks like. Final draft. So the subject line's descriptive, the email is addressed and closed properly, it states its purpose up front, it's polite, sentences are short, we edit and polish the draft. So should we go ahead and send it? You guys want to do more of this edit? All right. These two tasks we're going to try to move through quickly because I don't want to run out of time especially for the oral advocacy section, which I think should be a lot of fun. So, all right, so here is the force majeure provision in question for our second task, which is analyzing it, but more broadly, seeing how looking for ambiguities in contract language and then seeing how ambiguities could lead to a lawsuit. So let's try to do this quickly, though. I think we could spend a lot of time on this type of exercise. But can I maybe get one volunteer to identify some ambiguities in this provision, and then another volunteer to tell us how they could be drafted? And let me, while people are considering whether they want to volunteer before I volunteer them, voluntelling is where the person asking for volunteers actually picks someone and says, you have been volunteered. That's voluntelling. So the provision says, Section 25, force majeure. Force majeure means an event beyond the party's control, parenthesis, hurricanes, comma, tornadoes, comma, floods, comma, emergencies, close parenthesis, that interferes with the party's ability to meet their obligations, period. And that is the extent of the force majeure provision. So you want any event that's beyond the party's control to be covered, not only natural disasters. So you see how this would lead to litigation in this context, right? Because skeletons will say, well, no, this is the force majeure clause only applies to these very highly specific natural disasters. And I would argue we have this principle of, actually I forget the name of the principle, but where you have a list of items, if you have an ambiguous one, it should be interpreted sort of in light of the other ones. So that would be an argument in favor of interpreting emergencies as a natural, like an emergency of a natural disaster sort of type, because the other items in the list are all natural disasters. But the point is highly ambiguous, and that, you know, keeps litigators in business, but isn't what parties drafting contracts want. Any other, what about in terms of the latter part of this, and what the party claiming force majeure will have to show? All right, let's move on so structuring longer documents. So again, this is very difficult to cover in a seminar like this, because usually if we're looking at longer documents, we'd be in a room and we'd all have the document and we could mark it up. So I just wanted to leave you with 2 points that are really kind of offshoots of the points I made in connection with emails, which is, firstly, point first writing applies with even greater force in longer documents, whether they are pleadings or arguments to a court, like a factum, a brief, whether they are memos to a client, opinion letters, whatever it is, you need to have an executive summary or a recommendation or an overview, depending on the type of document, that summarizes everything that's important. And as you're writing it, you have to assume that if it's a memo to the client, that the CEO of your client will read it and will read only that and will not read the rest of the document. And that is likely to be true, by the way. Or the court, if it's the overview, the court will read the entire factum, but what many judges will tell you is they read the overviews from each of the sides' written submissions first, and they form kind of, that sort of sets the tone for the entire case. So you really want to include a very strong recommendation section or a very strong executive summary right at the beginning. So here we've said this is a memorandum to skeletons from the law firm. Recommendation, proceed with the action. So just like our subject line for the email, we're being very clear what the purpose of this communication is. In this memorandum, we set out our analysis of your breach of contract claim against Devil. In our view, you have good arguments that Devil may not rely on the force majeure provision. First, the provision does not apply to the current COVID-19 situation, as we just concluded. Second, Devil could still rent the skeleton costumes despite the COVID-19 situation. While Devil may make arguments that the force majeure provision does apply, these arguments are weak. Therefore, we recommend that Skeleton bring an action for breach of contract against Devil. And then obviously you'll have, you know, pages and pages, depending on how complex it is. It could be 20 pages of analysis, but this is the core, right? And that's really the only thing that a chief executive officer usually wants to know is, what do the lawyers say we should do? Okay, great. And then somebody else will read the detail, right? So always include that. And then sort of on the same note, you want the table of contents to communicate basically what your analysis is. And also, you want a reader to be able to skim only the table of contents and understand what you're communicating to them. So just compare and contrast the one on the left, which is just kind of very descriptive, I would say. Not even descriptive, it's kind of generic. And the one on the right effectively tells you what the various arguments are, what the various parts are. So the one on the right, of course, I would say is more useful to the reader.
All rise. The court, la cour. Madame Justice Hyunju Park presiding.
Good evening. Virtual hearing in the matter of Skeletons in the Closet Incorporated versus The Devil is in the Details Corporation. Counsel for the appellant, Ms. Myriam M. Seers. Counsel for the respondent, Mr. Thomas M. Riddle.
He didn't show up. Typical.
Counsel for the respondent, Mr. Thomas M. Riddle. Okay, Ms. Seers, please proceed.
You know, this is typical, Madam Justice Park. They never show up. They never do what they say they're going to do. This is just like, it's just constantly like this. And you can see what we've had to deal with since the beginning of having to deal with these people, Madam Justice Park. I mean, this case is an outrage, right? It's a travesty of justice. It offends the most basic notions of justice and fairness and public policy, that the devil would be allowed to get away with not paying for costumes. It contractually agreed to pay, Madam Justice Park. It deserves its name because the people working for it are devils.
Perhaps you could stick to your arguments.
Oh, sorry. Well, our argument is that the force majeure clause does not apply because epidemics were not listed. They were.
Yes, but.
Oh yeah, they were not listed as an event of force majeure.
Yes, but your friends, counsel for devil, make the argument that the examples do not limit the generality of the introductory language.
Just 1 minute. Right, yeah, right, sorry. Well, if I look at my outline, yeah, I'll get to that point a bit later, because what's important for you to understand is that there's nothing preventing them from renting the costumes. Nothing preventing them from renting the costumes. They could have had a spooky Zoom soiree, kind of like what we're doing right now. They chose not to do it. I mean, you know, you talk about counsel. No, Madam Justice, but you talk about counsel for devil, right? Mr. Tom Riddle, who didn't even show up, by the way. Are you really going to listen to him if he does show up? I mean, you know he's Lord Voldemort, right? I mean, he doesn't even have enough respect for the court to show up. He doesn't get a say.
Okay, but could you...
And that just goes on to show you that they act in bad faith, and they're just an untrustworthy company.
Counsel, we need you to address your opponent's argument. Please do so now.
Can you hear me?
Sorry, I'm here.
Can you hear me? Oh yeah, he shows up at the typical. Can you hear me? I can't. I can't hear you. I think I'm having some technical difficulties.
Perhaps we should try that one more time. Here's, this is your second chance.
Thank you, Justice Park. I'll be addressing these 2 points in my argument. My first argument is that devil cannot claim force majeure because there are options available to it to perform the contract which it chose not to take. My second argument is that the COVID-19 situation does not qualify as force majeure under the agreement. So turning to my first point.
Actually, counsel, we are more interested in your second argument. What do you say in response to your friend's argument that the examples are not exhaustive?
Certainly, Justice Park. In our submission, my friend's argument is inconsistent with the plain wording of the clause. If the examples were not intended to be exhaustive, they would be introduced by language such as including but not limited to, such as, or without limiting the generality of the foregoing, which is very common contractual language. The drafters of this clause included no language of that nature, and therefore...
Okay, but that doesn't address the issue of the reference to emergencies. There can be no doubt that the current situation is an emergency, can there? I mean, hasn't Cabinet issued several emergency orders already?
Well, thank you, Justice Park. Our argument is that emergencies, as it's used in the context of this particular clause, must be interpreted in light of the other examples and limited to natural disasters. But in any event, going back to my first argument, even if you find that COVID-19 is an event that can give rise to force majeure, devil doesn't meet the second requirement, which is the inability to perform its obligations. There's no evidence before you that COVID-19 prevented devil from holding its event. Perhaps they could have held it in a socially distanced way. The costumes come with face coverings that have a skeleton jaw print, and that may well have met the public health regulations. We don't know because devil did not provide any evidence about that. Perhaps they could have held a virtual event just like this hearing, which would still have made use of the costumes, but would have accommodated the current circumstances. If we can wear court robes virtually, Madam Justice Park, they could have worn skeleton costumes virtually as well. And again, we can't know because they didn't file any evidence. And in our submission, that falls far short of meeting the burden that a party claiming force majeure must meet. So we ask that the court find that devil breached the contract.
Thank you, counsel. Nice use of the subjunctive in your last sentence, by the way.
You put your, so I tried to give the court a roadmap at the beginning with my 2 arguments, and it's usually a good idea to put them in the decreasing order of importance. So most important first, and so that's why I started with the second one. But then as you see, the court often has a very different idea of what it wants to hear about and in what order. So she took me right back to the first one, which I then, so you're constantly having to readjust your submissions as the hearing goes on. And then courtesy to the court and to opposing counsel goes without saying. And even if opposing counsel is Voldemort, you need to be nice. So the idea obviously is if it would have arisen from a murderer who would have had put dead bodies in their closet, and so therefore they have skeletons in their closet, they have something to hide. So is that too colloquial, too casual, do you think, for courts to use this kind of expression? Or do you think courts do use such expressions? No, Vanessa says no.
I never read a case with this expression before.
Well, there's a first time for everything. Family law case describing the parties in a family law dispute where after describing the testimony of the mother and the father having, as family law parties do, presumably said very, very bad things about each other. The court says, each has skeletons in the closet, but they are dusty, which I love because basically what that means is they both were trying to hide some things, but it's all from a long time ago. It's dusty, so I'm not going to be too bothered by it. Up the ante. So it's a poker expression. So anybody who plays poker, you should kind of get the reference where the ante is like the buy-in for each round. And if you want to, you're like raising the bets by upping the ante. Say if the ante is $10 and you say, I'm going to raise the ante to $20, and then everyone else has to either match it or fold. So it's kind of it's a metaphor for raising the stakes. So the stakes, which is itself an expression, means increasing what is under discussion, increasing the importance of what is under discussion. So for example, if you have sort of in a legal context, you're negotiating a mergers and acquisitions transaction for, say, two small parts of the company, two small companies that are each part of larger companies, say, and then all of a sudden one of the executives say, no, actually it's the whole company or nothing. You buying the whole company or you're buying nothing, that is upping the ante. And of course, the courts have found occasion to use this expression as well. In this case, the Ontario Superior Court, in a case against by a construction company against the Globe and Mail newspaper, and it's in the general context of costs, so the amount of costs that that the construction company would have to pay the newspaper. And they say, if anything, the legislature has upped the ante, as it were, by enacting a presumption of costs on a full indemnity basis. So the legislature has increased what is at stake when we talk about costs by making this decision. They have upped the ante. Don't shoot the messenger. So I think maybe this exists in other languages too. It's the idea that the bearer of bad news is often blamed for the bad news. So, you know, if you're working on a deal and the client calls you to tell you that the deal is off and will not go forward, and you have to go tell your boss this information, if the boss freaks out and yells at you, you could say, oh, my boss just shot the messenger. So when I said up the ante, don't shoot the messenger, what I was getting at is you need to raise your game, or you should pay more, not pay more attention, but you should kind of take these issues seriously and raise the stakes for yourself, because your career is worth it and your development is worth it. But don't shoot the messenger. It might be hard, and that's, you know, don't be upset with me for bringing this to your attention. Embrace it. So that's what I was getting at. Obscure meaning, I grant you, but that was the point. So this is interesting. So the Supreme Court of Canada, in the SOCAN decisions about copyright, involved in whether I think it was, whether internet service providers would be liable for defamatory content that was posted on websites that they hosted. And it's interesting because the service providers describe their own theory of the case as don't shoot the messenger. So the fact that there's defamatory content on the websites that we host is not our fault. Don't shoot the messenger. The devil is in the details. This one I think also exists in a number of languages. It's the idea that it's really the small details of a matter that can be most problematic or make the whole thing fall apart. And it's very extensively used in commercial law because and as we've just seen with the force majeure clause, right? If we had accepted Vanessa's suggestion to put such as at the beginning of that enumeration of examples, which is a very small detail, the entire result would have been different in the case. And so the devil is in the details. Justice Lebel and Deschamps of the Supreme Court of Canada, in this case, opened their dissenting judgment by saying the devil's in the details, awareness of the critical importance of constitutional rights, and so on. Until hell freezes over means forever, because it is impossible for hell to freeze over. Therefore, it will never happen. Some other examples that's maybe a little older, but like that grandmothers or kids would use is when pigs fly, or when the I forget. There are others like that, but until hell freezes over is quite common. And this brings me to the slide I will leave you with, which is quite possibly my favorite quote from the Ontario Court of Appeal ever. And I need to set it up. All right, I will set it up. So actually, maybe some of you who are from Latin America will know about this case, Chevron and Ecuador. So, so in a nutshell, for those who don't know about the case, Chevron predecessors sued in Ecuador for massive contamination and oil spills in protected areas, and sued by local residents under a new right under Ecuadorian law that didn't previously exist, giving basically citizens a right of action for environmental damage in their private capacity. They win, and they get a judgment that's like $1 billion plus. I don't even know the amount. It's a lot. But it's tainted by corruption allegations and tampering in terms of how fair the process was in Ecuador and so on. And so there's been pretty much global litigation about it since it was issued, including an investor state arbitration claim brought by Chevron against Ecuador to prevent enforcement of the arbitration award internationally. What does this have to do with Canada? Well, the plaintiffs came to Ontario, not the plaintiff, I should say the class action lawyers representing the plaintiffs came to Ontario to seek enforcement of the judgment against the shares of Chevron Canada. So the judgment is against Chevron Inc., which is a US entity, and they're seeking enforcement against the shares of Chevron Canada. And to cut to the chase, they were unsuccessful on, it went to the Supreme Court, which anyway, the decision at the end of the day was that the shares of Chevron Canada are not available to the plaintiffs to enforce a judgment against Chevron Inc. So they protected the corporate separateness. But at this stage of the proceeding that I'm about to show you, the question was whether Ontario was a convenient forum, or whether the action should be moved elsewhere. So there's a quote at the end from a quote of a Chevron executive, but basically this is the end of the Court of Appeals judgment, finding that actually the action could proceed in Ontario, and that Chevron Canada, in other words, would have to continue defending itself here in Ontario because the case could go forward. Even before the Ecuadorian judgment was released, Chevron, speaking through a spokesman, stated that Chevron intended to contest the judgment if Chevron lost. He said, "We're going to fight this until hell freezes over, and then we'll fight it out on the ice." Chevron's wish is granted. Which is funny because the reference, if you look, it's December 17th, 2013. So it's winter in Ontario. So Chevron's wish is granted. They can fight it out on the ice. They can fight here in Ontario. Oops. I accidentally maximized. So that's it. I hope you enjoyed the presentation.